I object, Your Honor. Now, what good is that going to do me? Hi, Tony DeWitt here. I'm a Missouri appellate attorney, retired, and I bring you a fresh perspective on the law without offering any legal advice. So pull up a chair. This is what we're discussing today. What do you think when you hear an objection at trial? Do you sometimes wish you understood what they were saying? Many people do. Do you wish you knew how the judge was going to rule it? Do you think when you hear a hearsay objection and it sounds like hearsay, that the judge ought to sustain it? And when he doesn't, you're surprised. I don't blame you if you find these things hard to follow and difficult to understand. Evidence is pretty much a 1 year class in most law schools. But I think I can make it a little bit better for you here today. I can tell you some of the things that lawyers know that aren't necessarily general public knowledge, and I think I can make it so that, at least with respect to the most common objections, you understand what they're talking about. Now, let me tell you why this is important. First, knowing how the judge should rule and contrasting that with how the judge does rule allows you, as the citizen, to evaluate the judge's fidelity to the law. That's very important if you vote for judges in your state, and if you vote to retain them in those states where there are no direct elections. Second, if you pay attention to your local prosecutor and see how many times his objections are sustained, you'll have a better idea as to how well he is prepared for court. And if he is frequently the subject of objections that are sustained against him, that might indicate to you either that he doesn't know what he's doing or that he's playing dirty or both. These are the reasons I think that are important in terms of sort of understanding how the justice system works at the beginning. But third, knowing this stuff will allow you to amaze your friends and terrify your enemies, or something. Let's start with a few basic propositions. First, whatever is admitted into evidence at trial is fair game for the jury. Evidence comes in by questions, and a question that asks to admit objectionable evidence must be objected to, or the objection is waived. And if the objection is waived, then this objectionable evidence, maybe it's character evidence, can be used by the jury and the appellate court because it wasn't objected to. The objection must articulate the basis for keeping the evidence out. Now, oftentimes, what somebody will do, what a good trial lawyer will do, is object and say, "May I approach?" And then both parties go up and they argue about the objection. Sometimes the basis is obvious from the context, or sometimes somebody uses a one word, objection, hearsay, objection, relevance, that sort of thing. If the objection is sustained, then the answer can't be given. And if it's not sustained, if it is overruled, then that evidence is coming in. Now, in addition to evidentiary objections like that, there are procedural objections to how a question is asked. And that's not an objection to the evidence so much as the way the question is asked, or what we call the form of the question. For example, if a lawyer on direct asks a leading question,
would you agree with Mr. Leroy that if you don't follow each of these steps in a systematic fashion, then you don't have a reliable methodology?
Object, Your Honor, I think he's leading his witness.
that's improper, as all questions on direct, with the exception of some foundational questions that most people don't object to, must be by open-ended question. Now let's look at some of the more common objections at trial. First, let's look at objections based on the rules of evidence. Relevance is a frequent objection at trial. So to understand that, we first start with Rule 402, which says, relevant evidence is admissible unless any of the following provides otherwise: the United States Constitution, a federal statute, these rules, or other rules prescribed by the Supreme Court. And of course, that also means case law. Irrelevant evidence is not admissible. Now, that rule is supported by Rule 401, which tells us what is relevant and what is not. That rule says evidence is relevant if A, it has any tendency to make a fact more or less probable than it would be without the evidence. And B, the fact is of consequence in determining the action. So you could very well have a fact that made it more or less probable about something, but if it's not about the fact and consequence in determining the action, it doesn't come in. So evidence is only relevant if it has any tendency to establish a fact, and that fact is of consequence to the action. If the evidence doesn't go to an active issue in the case, it doesn't come in, no matter how bad it makes the defendant look. Another common objection is objection, hearsay. And there are usually two responses to this by the person trying to get the evidence in. The first, and often the most successful, is I'm not offering it for the truth of the matter asserted. You probably heard that several times in the Linda Sturmer trial. Where does that come from? Well, it comes from Rule 801, which defines hearsay as hearsay means a statement that 1, the declarant does not make while testifying at the current trial or hearing, and 2, a party offers in evidence to prove the truth of the matter asserted in the statement. And that definition covers about 90% of hearsay statements, but some statements that are hearsay are exempted from the rule. Rule 801 says a prior statement from someone testifying under oath and who is available to be cross-examined on it is not hearsay. A party opponent in a trial, for example, the defendant in a criminal trial. There are numerous exceptions to the hearsay rule, too. For example, the business records exception. The medical records of a patient in a malpractice action come in because they are kept by the hospital, maintained in the normal course of business, and they have the indicia of credibility. Now, explaining all of the different hearsay exceptions would probably be a different video, and if you want me to make that video, I'd be happy to do it, but it would make this video much longer and probably less effective. Generally, unless the statement is not hearsay under 801 or is not offered for the truth of the matter asserted, then it has to fit within an exception, and if it doesn't, it should not come in. That doesn't mean that sometimes judges say, go ahead and tell me, because sometimes they want to know the answer. Then there is objection calls for speculation. It calls for speculation whenever you ask what somebody might not have personally witnessed. All testimony has to be based on personal knowledge. If two persons were in a fight and the cops rolled up after the fight was over, they can testify to being called to a fight, but they can't testify that they saw the fight because they weren't there when the fists were being thrown. If witnesses saw the fight and gave statements, those statements are hearsay and they don't come in unless they testify or some other exception applies. For that reason, this objection to speculation applies when a witness is being asked to guess or assume something about which they do not have personal knowledge. Lack of foundation. Objection, lack of foundation. Think of foundation the way you do the foundation in a building. It holds up the rest of the structure. So in an assault case, if the cop takes the stand and the first question is, "What do you know about the fight between A and B?" The objection would be to foundation, because we don't even know if this cop has any information. We don't know who he is, what he does, how he was trained, how did he get there. All of that is foundational. That's why what often appears to be chit-chat at the beginning of an examination is important in establishing foundation. Please state your name. Who's testifying? Why is he testifying? How are you employed? Well, I'm a police officer. Where were you working on the night of June 5th? Well, I was working on patrol. Were you called to 1112 Meadows Place in Mount Hermon? Well, yes, I was. What did you observe? Well, I found two people nursing bumps and bruises all over their faces and hands. That's a proper foundation. And you get that proper foundation, and you have to get it through open-ended questions. So the prosecutor then establishes the reason why the witness is competent to testify to the facts asserted, because she built a foundation for him. So when you hear this objection, you know that the evidence or testimony hasn't been properly introduced or connected to the case. Objection, Your Honor, improper character evidence. Well, there is a whole rule on improper character evidence. Here, the attorney is introducing evidence of a person's character to suggest they acted in a certain way on a specific occasion. Outside of exceptions like truthfulness or criminal cases, usually a pretty good objection. Rule 404 sets the standard here. It says character evidence, prohibited uses. Evidence of a person's character or character trait is not admissible to prove that on a particular occasion that person acted in accordance with the character or trait. Exceptions for a defendant or victim in a criminal case. The following exceptions apply in a criminal case. A defendant may offer evidence of the defendant's pertinent trait, and if the evidence is admitted, the prosecutor may offer evidence to rebut it. So, if the defense offers evidence from, you know, John's mama to say that John was very calm and patient and would never hurt a flea, well, the prosecutor can bring in evidence from his girlfriend and who might say, he slapped me around quite a bit. So again, character evidence tends to open up the door for all kinds of collateral issues, and as a result, judges don't like it. So for the most part, character evidence is almost never admitted in situations like that, but it can be. Subject to limitations in Rule 412, a defendant may offer evidence of an alleged victim's pertinent trait. You should go read that rule to find out what it's about. A defendant may offer evidence of an alleged victim's pertinent trait, and if the evidence is admitted, the prosecutor may offer evidence to rebut it and offer evidence of the defendant's same trait. And in a homicide case, the prosecutor may offer evidence of the alleged victim's trait of peacefulness to rebut evidence that the victim was the aggressor. Now, there are exceptions for a witness. Evidence of a witness's character may be admitted under Rule 607, 608, and 609. So, if a witness is testifying, you can impeach them for credibility and things like that. And then other crimes, wrongs, or act, prohibited uses. Evidence of any other crime, wrong, or act is not admissible to prove a person's character in order to show that on a particular occasion the person acted in accordance with the character. Permitted uses. This evidence may be admissible for another purpose, such as proving motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. Now, there have to be some notices given, and that usually applies in the criminal context. Again, that just allows the other side to be ready to argue the issue or file a motion in limine to try and keep it out. So this objection says, let's look at the rule and see if this fits. If it does, it can't come in. But if it fits an exception in a criminal case, it can reasonably be shown to relate to motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident, then it's going to come in. And then there are those procedural objections. Objection, leading question. You were at the laundromat. Objection, leading. You saw the defendant jimmy the lock on the change machine. Objection, leading. You saw him take the money. Objection, leading. You have to get those things in on direct exam, not through leading questions, but rather through open-ended questions. A question that suggests its own answer is a leading question. Those were all leading questions because they could have been answered yes. Calls for narrative. Calling for narrative happens when you ask somebody to narrate the sequence of events that you haven't first established. So, if several things happened in the course of an event, somebody walked into a restaurant, somebody ordered a meal, somebody ate the meal, somebody walked out without paying, you would want to get each of those facts established independently, and then you could ask a summary question. So you're saying that the person came in, ordered meal, ate it, didn't pay for it, and left. That's okay. But what you can't do is say, tell me everything that happened after Mr. Jones arrived at the restaurant. That is asking for narrative, and it's going to draw an objection. Objection, asked and answered. You've probably heard that several times in the Sturmer trial as well. The attorney is repeating a question that has already been asked and already been answered. Objection, argumentative. This happens when the lawyer is trying to confront the witness or provoke them. Did you see the no processing sign? Why, no, Mr. Prosecutor, I did not. You missed an 8-foot square sign hanging directly over the entrance that said no trespassing. Are you blind? Well, as you might guess, that would be fairly argumentative. And unfortunately, a lot of times lawyers take that approach. Usually a judge will rebuke you for that. Hey, that was over the top. Calm down. I'm going to call a recess and you're going to get yourself under control. So, again, if somebody is confrontational or provoking a witness, that is something you're not allowed to do. Objection assumes facts not in evidence. This usually happens when the witness is out of order on the direct examination. In other words, he was supposed to testify on Tuesday, but instead he got bumped up to Monday because of another witness's schedule. So the prosecution's already prepared the questions for him, and they ask something like, "So you knew that Axel was under the influence at the time he was arrested?" The objection would be to both foundation and to stating facts not in evidence because the question includes facts that haven't been established in court yet. They were going to come in through the toxicologist who was supposed to testify on Monday. But that didn't happen, so now the prosecutor has to back off and not ask that question. Misstates the evidence. A lot of times lawyers try to weasel word things. And if they get a witness to answer a question and they don't like the answer, a lot of times they'll change the question so that they get the answer. But if they misstate the evidence, if they misstate something that's come into court already, well, there you have a huge problem because now, you're trying to gild the lily or you're trying to essentially mislead the jury. And of course, you can't do that. If you mislead the jury, if you do it intentionally, that can reverse the verdict that you get if you get one. So it usually happens, though, when prior testimony is vague or the lawyer's trying to get around something. Suppose the witness previously described a light brown coat on the defendant, and on cross, the lawyer leads with, "You say the defendant had on a gold coat." Well, you can't do that because you know that he had on a light brown coat, it's not proper, and you'll draw a misstates the evidence objection. So, non-responsive. Objection, non-responsive. The witness's answer doesn't respond to the question asked. This is a questioner's objection. The lawyer asks, "Why did you open the door?" I was thinking like that scene in Friday the 13th, the one where Jason pops up and gets his point across to the victim. So I didn't want to open the door. Well, the question was, why did you open the door? Not why did you not open the door, because it's already been established that you opened the door. So a non-responsive answer is likely to get a motion to strike and that objection, non-responsive, move to strike. So the judge will usually strike that answer and direct the witness, answer the question, "Why did you open the door?" Now, witnesses don't like that. And indeed, in one of the cases that we looked at earlier this year, one of the witnesses almost got contempt of court because he didn't want to answer the question the way it was asked. But non-responsive answers don't do anybody any good, and so those are properly objectionable. Objection, cumulative. This is a rookie mistake. You dump all the evidence you have on a critical fact. If 10 people saw the shooter, you have 10 people testify. Unless the witness has something remarkably different to say, that objection is going to be sustained and the witness is not going to be allowed to testify because the evidence is redundant. It repeats what's already been established. You don't need to beat it into the jury's head 10 times. And in fact, it's to your benefit not to because, frankly, that ticks off the jury. Improper opinion. Objection, improper lay opinion, or objection, he lacks an expert's qualification. A layperson, somebody who is not testifying as an expert witness, can offer opinion testimony at trial under certain conditions. In federal courts, this is governed by Rule of Evidence 701, which limits lay opinion testimony to specific subjects. A lay witness may offer opinion if it is rationally based on their perception, meaning it's something the witness personally observed or experienced. It looked to me like there was gasoline in the water because you could see that odd swirl of color on top. Helpful to the understanding of the witness's testimony or determining a fact and issue. The opinion has to aid the jury or judge in understanding what happened. It sounded to me like a gunshot, not a backfire. not based on scientific, technical, or other specialized knowledge. If it requires special training or expertise, it's for an expert witness, not for a layperson. Clearly, my mom had mycoplasmic pneumonia. I looked it up on WebMD. Well, that opinion is not coming in because that's clearly an expert opinion. But here are some of the common subjects where lay opinion is allowed: speed, distance, size, weight. The car was going about 50 miles an hour, it looked to me. Appearance, condition, or state of someone or something. She looked very tired and pale, or the house looked run down, or the car was really rusty. Emotions or demeanor. He seemed very angry. She was very nervous. Voice or handwriting identification. You may recall in the Murdaugh case, there were several people who identified Alex Murdaugh's voice on the recording from the kennel. Intoxication. He appeared drunk. He was slurring his words and stumbling. Value of property. If somebody knows what the property is worth and can testify to it without using, expert language, they can do that. And general observations of behavior. Looked to me like the two of them were arguing. Lay witnesses can't give opinions on matters that require technical or expert knowledge, like medical diagnoses, accident reconstruction, psychological states beyond surface level perception, forensic conclusions, financial projections, or technical accounting issues. Those are the kind of things that are going to require an expert. So that's the proper objection when a lay witness is giving an opinion that they're not qualified to give. Objection, badgering the witness. This is a situation where the attorney is just relentlessly poking the bear with a witness. The attorney is harassing or intimidating him. You're ugly and your mother dresses you funny, that kind of thing. That's badgering the witness. It's not ever proper. In addition to those objections, there are objections to opening statement and improper argument in closing argument. And those are for things where usually not related to a rule, but they are related to common law where someone is trying to get sympathy for a client, for example, or they ask the jury to send a message, or if they did not ask for a certain amount of money in damages in their first part of their closing in a plaintiff's case, and they come back in the rebuttal and ask for a large amount of money when the defendant is not going to have an opportunity to respond to that, that's improper argument. So that preserves for appellate review where a lawyer is not playing fairly and the lawyer on the other side is afraid he might very well lose. When a judge gets one of these objections, he first listens to the basis of the objection, and if it's necessary, he'll call a bench conference and let the lawyers argue it on the record before making a ruling. If it relates to something that was said earlier in the trial, he may ask the court reporter to go find that testimony so he can review it. Objections are the speed bumps in a trial. An attorney has to be judicious about making them. They can't let in evidence that harms their client, but they also can't be popping up every 2 seconds and objecting because it signals that in that regard, their case is pretty weak. And it is possible to annoy both the judge and the jury, which is something you absolutely should never do as a lawyer. So that pretty much covers the general subject of objections at trial. If you have any specific questions about specific objections, send them to me in an email, and I will be happy to go over them with you. Be happy to do a video if you'd like. That's what I have for you today. I hope you found it helpful, interesting, or maybe both. If there's a subject you'd like me to discuss, please feel free to send me an email at the address above. If you like what we do, please feel free to subscribe and come on back to the beach tomorrow. I release videos every weekday, weather and work permitting. If you have the opportunity today, do a kindness for your fellow man. It makes the world a better place, one kind act at a time. And now, YouTube has some suggestions for other videos of mine that you might like.